And live now to the Privacy and Civil Liberties Oversight Board. They are holding a public forum this morning to discuss the USA Freedom Act, a modified extension of the Patriot Act, which expires at the end of the year if Congress doesn't authorize it. This is live coverage here on C-SPAN 2. It started about 2 minutes ago.
All members and the entire PCLOB staff have security clearances, so the board's work can be based on a factual understanding of intelligence programs and operations that is complete. The board's mission is to ensure that the executive branch's efforts to prevent terrorism are consistent with the need to protect privacy and civil liberties. Much of the board's work relates to technology. The use of emerging technologies, whether by people and organizations or by intelligence agencies, creates both opportunities and challenges for privacy and civil liberties. That's why the board has established a strategic goal of conducting rigorous analysis of new and emerging technologies and how they affect efforts to protect the nation against terrorism and the preservation of privacy and civil liberties. The board has two main functions: advice and oversight. Under the advice function, agencies can consult with the board at an early stage in the development of new policies, programs, or procedures to ensure that privacy and civil liberties are factored into the initial design of those programs. Advice engagements are confidential and allow agencies to get an independent assessment of potential risks before deciding how to proceed. The board does not speak publicly about specific advice projects unless the relevant agency and the board have agreed to publicly acknowledge the advice. Under the oversight function, the board engages in in-depth reviews and analysis of actions the executive branch takes to fight terrorism, and the board assesses whether those security measures are consistent with the protection of privacy and civil liberties. The board holds briefings with agency representatives, reviews documents, and produces reports and recommendations. Some of the board's reports remain classified and some are published. We strive for transparency, consistent with the need to protect classified information. In all cases, the board strives to make recommendations that are pragmatic and actionable to increase the effectiveness of programs in protecting security, privacy, and civil liberties. In conclusion, I'll note that the board's previous work on Section 215 of the Foreign Intelligence Surveillance Act was conducted under the board's oversight authority, and our current work on the USA Freedom Act and the Call Data Records Program is a continuing exercise of the board's oversight authority. And with that, I'll pass it to my fellow board member, Jane Nitze.
Thank you. I'd like to also reiterate my thank you to the panelists for coming and testifying before us today, and also for members of the public for attending as well. I'll use my time to talk first briefly about the board's past work on the telephone records program conducted under Section 215, and then turn briefly to the USA Freedom Act, which codified many of the board's recommendations that it issued as part of its review of that program. I know for some this will be old and new, known news, but just bear with me. So the board's engagement with the telephone records program began shortly after the Snowden leaks. Some of the articles based on those leaks described an NSA program that collected millions of telephone records, including records of purely domestic calls. Disclosures, as we all know at this point, caused a great deal of concern among policymakers and the wider public. And about 1 week after the initial articles were published, a bipartisan group of senators approached the board, which had been newly reconstituted at that point, and asked it to investigate the program and provide an unclassified report so that, and I quote, "the public and the Congress can have a long overdue debate about the program and the privacy issues it raised." The board did just that, and about half a year later issued an unclassified report in January of 2014. The report contained an extensive and detailed factual description of the program. Many of the facts contained in the report had been declassified at the request of the board and offered the public greater insight into the program and its privacy impact. As the report described, under the historical telephone records program, the government had been collecting call detail records in bulk under Section 215 with the approval of the FISC. The report also contained extensive policy and legal analysis and concluded with 12 recommendations. The recommendations included those directly impacting the operations of the program, those seeking to promote transparency, and those that address the FISC. For instance, the board recommended that the court hear additional independent voices when considering certain governmental applications. A little over 1 year after the board issued its report, the USA Freedom Act became law. So this was June of 2015. Among other things, the act significantly reformed the telephone records program. Among its more significant reform measures was to require the government have a specific selection term, so an SST, which is sometimes called, to be used as a basis of obtaining any tangible things, and to require that a judge, instead of executive officials, determine that the selector term met a, quote, reasonable articulable suspicion standard, often called a RAS. Some provisions in the USA Freedom Act contained a sunset date of this upcoming December. Notably, among these sunset provisions is the current form of Section 215. Today's event will focus on, in particular, the telephone records program after the passage of the USA Freedom Act, although we welcome our panelists to testify about any provisions of the Act that they think useful to discuss at this forum. And as I said before, we very much appreciate you taking the time to be with us today, and we look forward to your comments.
Thank you. I'll now introduce briefly our first panel. Caroline Lynch is the founder and owner of Copper Hill Strategies. Ms. Lynch previously spent 15 years on Capitol Hill, including 10 of those years as a senior staff member of the House Judiciary Committee, where she worked on various pieces of landmark legislation, most notably for today's purposes, the USA Freedom Act of 2015. Susan Landau is the Bridge Professor of Cybersecurity and Policy at the Fletcher School of Law and Diplomacy at Tufts, with a dual appointment in the university's Department of Computer Science. She's the author most recently of the book Listening In, Cybersecurity in an Insecure Age, and she's also received numerous honors and fellowships and authored many other publications on technology and national security, which are too numerous to list here. And finally, with us on screen is Jamil Jaffer, who is the founder and executive director of the National Security Institute at George Mason University's Antonin Scalia Law School, where he's also an assistant professor of law. He is also vice president for strategy and partnerships at IronNet Cybersecurity. Professor Jaffer has prior experience as a senior staff member on the Senate Foreign Relations Committee, on the House Permanent Select Committee on Intelligence, and in the Justice Department's National Security Division. We'll go first to opening remarks from Ms. Lynch.
Thank you, Chairman Klein and board members. It's a pleasure to be here today. I appreciate the invitation to speak with you about the USA Freedom Act and specifically the call detail record authority created under the Act. I just want to begin by noting that the USA Freedom Act is not a piece of legislation that was undertaken lightly. It is probably one of the better examples of legislative sausage making involving a 2-year process that was bipartisan, bicameral, and involved input from a variety of outside sources and multiple federal agencies. And so despite news reports about how the authorities have been implemented, I just want to stress that it truly was a concerted effort by Congress to get it right. I thought I'd begin just with providing a little bit of background about Section 501 of FISA, or what's more commonly known as Section 215. Created in 1998 by Congress, it originally had a relatively narrow scope and standard that was expanded twice through Patriot Act reauthorizations in 2001 and 2005. Ultimately providing a standard that I think is important to the conversation today about the NSA's bulk telephony metadata program and how Congress constructed the call detail record program. And that is, the standard is essentially a statement of facts that there are reasonable grounds to believe that the business records or tangible things that are being sought are relevant to a foreign intelligence investigation. It was that standard that the government relied upon when it sought to transition the telephony metadata program from the president's surveillance program under Section 501 or Section 215 of FISA. And so with that authority approved by the FISA court, the government was able to collect large volumes of telephony metadata on the premise that once analyzed and queried, they would find relevant records inside that trove. And so that program continued for several years with large volumes of metadata, including information about Americans being collected and then stored and analyzed when the government would have an identifier or a specific selection term related to a potential terror suspect. I think it's also important to note that while we're talking extensively about the call detail record program here today, Section 215 It also serves as the authority for the FBI to gather third-party business records in both counterterrorism and counterintelligence investigations, what the Director of National Intelligence will call traditional 215 authority. And was a driving consideration in how Congress crafted the call detail record program within Section 215 in an effort to preserve the FBI's quote-unquote traditional use of that authority. I thought I'd speak for a moment about how Congress responded to the Edward Snowden leaks of June 2013, just to provide some context for the board and the members of the public here. In June 2013, Congress was in between authorizations, if you will. So in 2011, Congress had reauthorized the USA Patriot Act. In 2012, Congress had reauthorized what's known as the FISA Amendments Act, and that is the source of Section 702 of FISA. Typically, members of Congress are briefed about the classified use of those authorities in conjunction with an impending sunset. In addition, in between those reauthorizations, we had an election. So we had new members of the House. And at the time, FISA was really not at the top of the minds of Congress. Working with FISA presents a challenge for Congress compared to other statutes in that while the act is public, the use of the act is largely classified. So while members are privy to classified information as a function of their election to Congress, routine oversight is typically conducted by the committees of jurisdiction and their staff. And so when the Snowden leaks occurred, a number of members were unaware of the existence of the program, either because they were newly elected to Congress, had not availed themselves of the classified briefings, or frankly had forgotten what they had learned a couple of years earlier, given the volume of information that they have to consume. I think another challenge was that the document that Edward Snowden provided to news outlets was what we refer to as a secondary order. That order is what is essentially the ability to compel a provider to comply with a primary order issued by the FISA court. If in reading the secondary order, a number of people in Congress and the public concluded or believed that the FISA court was acting as a quote-unquote rubber stamp to the government's requests, because at the time, the primary order remained classified and they were unable to see the volume of analysis that the FISA court undertook in issuing that order. So all of those things combined kind of created a perfect storm of concern and confusion on Capitol Hill. From there, the committees quickly turned to holding public hearings to the best of their ability, despite the fact that the programs had been revealed through leaks. They remained classified. So the challenge for the committees was how to start sharing information with members of Congress and the public while the programs were still largely classified. But we undertook hearings in July and the fall, and then continued hearings following the board's report on 215 and the president's surveillance group report that came out at the end of 2013. And so from there, the process continued until we were able to achieve consensus right on the heels of the expiration date in June 2015, June 2nd. As you mentioned, the call detail record program attempts to provide a more targeted version, if you will, of metadata collection. So rather than the records being collected in bulk and stored by the NSA to be queried later, the call detail record program, modeled after reforms that were implemented by President Obama in early 2014, requires the government to seek a court order to then, based on a reasonable articulable suspicion, to then collect the records from the telephone companies. They are allowed to collect stored records, but also records on an ongoing basis for up to 180 days. The challenge for the negotiators in creating this structure is, again, how could we create the CDR program, prohibit bulk collection, and preserve the FBI's traditional authority all within one section of the law? And so the approach that we decided to take was to maintain the quote-unquote relevancy standard, the standard of a reasonable belief that the records are relevant, while adding the additional requirement of an SST, or specific selection term. The specific selection term requirement serves as the prohibition on bulk collection by requiring that in every application that is submitted under Section 501, it intends to prohibit the indiscriminate bulk collection that had occurred previously. But the challenge for the SST definition is it also was important for us to not dramatically interfere with or modify the FBI's traditional use. So we spent a great deal of time working on that definition to try to get that right. As I mentioned, the collection can occur on an ongoing basis for 180 days, and there are additional requirements with regard to minimization procedures and the use of the information as it pertains to U.S. persons. Obviously, there's been some issues as of late with regard to implementation of the call detail record authority. And as you noted, Chairman Klein, there was a report last summer of over-collection that resulted in the NSA actually destroying a good deal of records that had been collected since the implementation of the program. And it appears from news reports that as of late, the NSA is no longer intent upon continuing the program. This presents then a question for Congress on how to approach reauthorization before December 15th. And I thought I'd briefly outline a few options that Congress has as that deadline approaches. The first option is that Congress could simply allow for Section 215 to expire. In doing so, the call detail record authority would be effectively repealed, but it would also repeal, it would functionally repeal all of the other reforms made to Title V of FISA. In particular, the standard upon which the FBI relies for its traditional FISA business record requests. It would eliminate the SST requirement and therefore the affirmative prohibition on bulk collection. It would also eliminate other reforms related to expanded FISA court review of minimization procedures, expanded non-disclosure authority or authority to challenge non-disclosure orders, and several other reforms. In addition to that, the other two expiring provisions that don't get talked about as much, but roving authority and the lone wolf definition would also expire. And in my opinion, I don't think that's the right approach for Congress to take at this time, both while international terror threat continues and with heightened foreign counterintelligence responsibilities. The second option for Congress would be to actually open up the statute to repeal the CDR portion of Section 501. I would caution Congress to be careful in doing that. There are multiple cross-references and reporting requirements and other structural changes that would have to come with that. But in doing that, they could preserve both the SST requirement and the reasonable relevancy standard, and therefore kind of return back to the intent of Congress prior to the leaks of 2013. The challenge with opening up the legislation, if you will, in that way is that it would allow for amendments addressing a variety of other topics to be made to the bill, including those that could be incredibly controversial and politically divisive on Capitol Hill. And with the timing of the expiration being just a few weeks before we're officially in a presidential election year, I think that is a potential heavy lift for Congress in the remaining months. The final option would be what we call a clean or straight reauthorization, a simple change of the date. Doing that would keep the CDR authority technically on the books, which I know a number of members of Congress are not supportive of doing. But at the same time, if it is true that at this point that authority is not going to be taken advantage of, it's not the first time that Congress would have left something on the books that is no longer in use or has outlived its usefulness for any reason. And at this point, I think that is likely the most politically expedient option for Congress to resolve this before, again, entering into a presidential election year. So with that, I'm happy to answer any questions you have.
Great, thank you. I think we'll hold our questions for all three panelists until after the opening statements. Professor Landau?
Thank you. So thank you very much, Chairman Klein and the board, for inviting me. I'm very pleased to be here. I'm here, my postdoc, Asif Lubin, and I started looking at the question, originally we were going to look at the question of why the collection had been so efficacious, as we'd been told by former Deputy Director Rick Leggett 2.5 years ago, that the collection was going great guns. And then we discovered, no, before Asif came to work with me, we discovered, no, there was a problem. And so we've spent a lot of time trying to understand the problem, and we have written about that, but I'm going to confine myself today to the other half of what we've thought about, which is efficacy and how well the CDR collection works in current days. So when you look at the question of privacy and civil liberties and you look at authorities that may impinge upon them, the question you want to consider first is the program efficacious in doing what it's supposed to do, countering the terrorist threat? And if it's not, then you don't even necessarily need to get to the question of balance and trade-offs. The program came about in part because of a call from between San Diego and Yemen, where the NSA was listening in on a satellite call. They didn't realize that the communication was with San Diego, and while they heard planning of a terrorist plot, they actually thought the targets were not in the United States, and they paid somewhat less attention as a result. And you have a quote from Michael Hayden, who later said, well, if we had the 215 program in place, we'd have thrown selector at the massive phone bills, and ka-jing, we would have come up with a number. But there are a number of changes that have happened since the summer of 2001, changes technically and socially in the way we use communications and the way terrorists communicate, and I think that has affected the value of the program. The first is that in Yemen, as across almost all of the world, when I looked at the World Bank statistics the other day, the exceptions were Samoa and a few other island nations and nations where there's been tremendous civil war and upheaval. But essentially across the world, the penetration of cell was minimal in 2000 and quite high by 2010. And what that meant is that not only people carried cell phones, but it meant also that the switching technology had changed. And so that technology enabling the data to say, oh, there was a call between a safe house in Yemen and San Diego became much more available. But the other change that happened, the other two changes that have happened are even more significant. The first is we've gone from the threat of Al-Qaeda to the threat of ISIS. And Al-Qaeda, as I'm sure everybody remembers, was a very tightly directed set of terrorist attacks. Everything went through, you first go to a training camp in Afghanistan, in various places. You go to a training camp, you are directed as to what to do. The terrorist, not you, but the terrorist is directed as to what to do, and very tightly controlled by essentially the corporate management of Al-Qaeda, which funds different parts of the attack, which communicates with the terrorists up to the moment of the attack. ISIS doesn't work that way. ISIS, from the start, tried to recruit foreign fighters to come to Iraq and Syria. They did it through a number of different social media efforts. Of course, the horrible videos we all know about. As people evidenced interest in anything, they followed up with reaching out to the individuals and then moving to encrypted communications. The terrorism that happened in Europe is quite different from the ISIS-inspired terrorism that has happened in Europe is quite different from the ISIS-inspired terrorism in the United States. Europe faced thousands of European fighters going to Syria and Iraq and fighting with ISIS and coming back. The U.S., by contrast, has faced 300. 300 people are relatively easy to follow for U.S. intelligence as they come back, to the extent that they've been permitted back. And Section 215 authorities are not particularly relevant to them. The European terrorists, whether you look at the Paris attack or other attacks, you see actual direction from ISIS into the attacks. The attacks in the U.S. have been homegrown violent extremists. They are radicalized at home through the violent videos. They sometimes communicate with ISIS recruiters, but the kind of communication is stab people, rent a truck and drive down a bike path. It's not do this at this moment. It's not direct kinds of control. And in that sense, we have a couple of different changes. One is we don't have that tight control that enables discerning who and what the plot is. But the second piece is that the communication is not occurring via calls. It's not over the telephone network. So now we need to go back to 2006. In 2006, Facebook became an application that the public could use. In 2007, the iPhone was introduced. Facebook became the killer phone app for the iPhone. And so now you have two communication modalities on one device, something that computer scientists and communication specialists think about all the time, but the public largely doesn't. One goes over the traditional public switch telephone network and leaves CDRs, whether you're talking about telephone calls or SMS. But the other, whether you're talking Facebook, Google, whether you're talking Telegram, or one of the encrypted applications, goes via IP communications. Now, there's been analysis, and Carolyn can confirm that the way Section 215 or 501 is written, IP communications are fair game under 215. But there's the legal ability to do it, and the ability to do it in terms of, is it the right tool to use? So when you use a telephone communication.
We are going to break away from this live event momentarily for live coverage of the U.S. Senate. Lawmakers are meeting today in a pro forma session with no votes scheduled. We'll return to live coverage shortly. Live now to the Senate.
The Senate will come to order. The clerk will read a communication to the Senate.
Washington, D.C., May 31st, 2019. To the Senate, under the provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable Martha McSally, a senator from the state of Arizona, to perform the duties of the chair. Signed, Chuck Grassley, President pro tempore.
Under the previous order, the Senate stands adjourned until 3 p.m. on Monday, June 3rd, 2019.
A quick pro forma session in the Senate. Lawmakers return for legislative work on June 3rd. And now back to live discussion on the USA Freedom Act.
10 different applications next week, and having to explain to the FISC what kind of details you're collecting on the call detail records of IP communications made 215 not a good vehicle when we have 702. And if you look then at 215 versus 702, and you look at the IC's, the intelligence community's approach to 215 and 702, early on, the IC began saying how important the capabilities that 702 was, and how much it prevented attacks. When you look at the discussion on 215, it gets wrapped up in a discussion of all our authorities are very useful, they help prevent attacks. But 215 is not singled out. I would say that the IC's communications about 215 are tepid at best, whereas 702 is described as essential. So when I look at the question of call detail records, what I see is a change in communication modality in the way all of us use communications and the terrorist as well. I see a change in organizational structure where you go from a corporate level, connect with the actual terrorist and plan the plot, to a almost peer-to-peer, we're going to radicalize you and have you do an attack. And I see the communications following suit. And the CDRs are just much less useful. So there are, of course, questions of privacy and civil liberties and the question of the large numbers, which I think are not actually that hard to explain, but I know that you're talking directly with NSA on that. But I think the place to focus on is efficacy, and how should the U.S. government assess efficacy of a program? And I think you guys should also look at that as well.
Thank you. Professor Jaffer.
Thank you, Chairman Klein and members of the board, and to my co-panelists. I appreciate you all being here today, and I really appreciate you allowing me to testify by video conference from Chicago. I'm supposed to be testifying in a terrorism trial later today, and jury selection ran over, and so my testimony doesn't come on until later this afternoon, so I appreciate you making this accommodation. Chairman Klein and members of the board, I want to thank you for inviting us here and actually having this discussion. You know, all too often, when we're looking at these counterterrorism authorities, particularly the ones that expire on a regular basis, we often have the debate about these authorities at the last minute, as the provisions are about to expire, as Congress rushes to correct their own sort of built-in flaw of creating expiring authorities constantly, and goes to fix them and modify them or just reauthorize them clean right at the last minute. And so it's great that you guys are holding this hearing 7 months in advance of the expiration of these critical provisions, and that we're able to have this conversation in public. Too often these conversations happen behind closed doors without the ability of the public to see what's being said about these authorities, what the options are for the government, and what the real value of these programs is. So I really want to compliment you, Mr. Chairman, and your board members, Ms. Nitze and Dr. Felton, for holding this hearing today. Now, look, I think part of the important thing to keep in mind here is that we are under, as Caroline correctly pointed out, a very real terrorist threat. It's easy today, almost 2 decades since the 9/11 attacks, and having lived in the relative safety that our aggressive intelligence collection, our aggressive actions against terrorists overseas, both our military intelligence operations against terrorists overseas, have left us fairly safe. And so it's easy to forget the 3,000 people that died that day and the huge impact those attacks had on our nation. It's also easy to forget that we remain under that threat constantly and every day, every minute. Our allies in Europe see that threat happening in their cities on a daily, weekly, monthly basis. They're disrupting threats, and we've seen those threats come here at home. And so the threat of terrorism remains ever present. In fact, the DNI testified before Congress just earlier this year and said that both Al-Qaeda and ISIS remain committed to conducting attacks here in the U.S. homeland, as well as against our allies in Western Europe and across the globe. And so there's no doubt we've made gains against ISIS. Their territorial base, the caliphate, has largely been decimated. That being said, the DNI points out they still control thousands of fighters in the Iraq-Syria region, have thousands of supporters around the world, 8 franchises still active, and dozens of networks still operating around the globe. In addition, the threat from Al-Qaeda remains ever present. While we may have been successful in getting Osama bin Laden, Ayman al-Zawahiri, and the rest of the Al-Qaeda organization, including its affiliates around the world, remain committed to attacking the U.S. here in the homeland. And we need not forget about the threat from Iran. Iran has often used its proxy force in Hezbollah to go after the West and the United States. And as tensions increase with Iran, as we've begun to go back to maximum pressure, increasing our sanctions on them to reach a better nuclear deal, Iran is likely to conduct terrorist attacks against the United States and our allies, both in the Middle East, as well as potentially here at home. Indeed, we know that the DNI told us that just last year, Belgium and Germany disrupted a threat against an Iranian opposition group where a number of both American and European diplomats were expected to attend. We've also seen the very real consequences and human suffering that comes from terrorist attacks. As recently as last month, we saw a terrorist attack conducted by an ISIS-affiliated group or ISIS-inspired group in Sri Lanka, with over 300 killed and 500 plus injured. These are very real consequences that can come here and come to the U.S. homeland. So as we discuss whether we ought to reauthorize counterterrorism authorities, whether we ought to modify them, we need to keep in mind that what has kept us safe in the almost 18 years since 9/11, relatively safe, are the fact that these terrorism authorities are there, they're being utilized, and that we have brought the fight to the terrorists not here at home, but overseas where they live and operate. So we need to maintain those capabilities, and in my view, not only maintain them, but actually expand them. We have, in the last 20 years, since we established these authorities, taken a step back. We've begun limiting our intelligence collection under Section 702, which, as Dr. Landau correctly points out, is one of the most valuable collections of foreign intelligence. When Congress reauthorized it last year, they put in place provisions to limit the scope and nature of the collection we can get under Section 702. Under Section 215, we've seen similar changes. After the illegal revelations by Edward Snowden a few years ago, Congress took action in 2015 to dramatically reduce the scope and nature of the Section 215 program, as both Caroline and Dr. Landau pointed out. Now, it is certainly true that the threat has changed, that the threat is larger from ISIS today than it was from Al-Qaeda before. Dr. Landau is also correct in pointing out that there's more of a peer-to-peer relationship and the communications technology has changed. But that's an argument for broadening our authorities to a broader set of communications technologies, not taking tools off the table. The fact that ISIS terrorists are being inspired in the United States and that there's an active, ongoing, day-to-day recruitment effort by ISIS against terrorists in the United States is a reason to expand our counterterrorism authorities, not limit them. Now, there are those who say that recent decisions by the NSA to limit its own collection or to even potentially, allegedly, terminate the collection under this program suggest that we ought to get rid of the legal authorities. Nothing could be further from the truth. While it's true that this position is not crazy, right? It's supported by privacy and civil liberties groups across the political and ideological spectrum, all the way from the ACLU to Freedom Works to Tech Freedom, and it's supported by a bipartisan and bicameral group of members of Congress. It's ultimately wrong. And the reason why it's wrong is this. While there were compliance incidents under the original 215 program, there was never, not one single example of intentional abuse or misuse of that program. And to be fair, the number of queries on that program, while the program itself was massive and tremendous numbers of phone records were collected, the number of queries was fairly small. In 2012, prior to USA Freedom, the number of queries was 288. In 2013, that number grew to 423. And in 2014, it went down to 161. The impact on U.S. persons was also minimal during the pre-USA Freedom 215 program. In 2013, 248 known U.S. persons were affected by the program. In 2014, 227 individuals. These are all public reports made available on the DNI's website that anyone in the audience or the other panels can take a look at. Now, the truth is there are still concerns about collecting this large amount of information. In fact, I remember when being read into the 215 program in 2007, I myself was uncomfortable with the nature and scope of all of these call records sitting in a data warehouse at NSA. But what gave me comfort was the fact that we had strong safeguards in place and that we had very distinct procedures and very careful procedures and very careful oversight by the FISA court and by outside authorities, including the inspector generals of the IC and various agencies. Now, the truth is that there were mistakes made. Compliance incidents did happen. But what's important to remember about those compliance instances, they were all self-caught, self-reported, and self-corrected. And not a single one, not one, in the over a decade of the program that program functioned under court authority was one abuse intentional discovered. Not one. And so the question then becomes, did USA Freedom make sense? Right? Was that the right approach? Was reducing our authority at a time when the terrorist threat continues to remain strong the right approach? We need not re-debate that question. The question before us today is, do we reauthorize USA Freedom? And the answer to that question is undoubtedly yes. The terrorist threat remains huge. Congress has authorized this program after looking at it closely in the aftermath of the Snowden revelations. And there's no reason to take tools off the table, even if the NSA has voluntarily chosen today to reduce its collection, if that story is even true. And assuming that's true, right, the question becomes what happens tomorrow when we need that authority? If Congress takes a tool off the table and we're in a situation where NSA can do it lawfully and can do it without having compliance incidents, why do we take that tool off the table? In a world in which the terrorist threat is real and remains constant, we must be cautious and constantly ever vigilant to not take tools off the table out of a sense that there may be some abstract threat to U.S. persons' privacy and civil liberties, when in fact the threat has not been proven to be true. Thank you, and it's excited to hear questions from the members of the board.
Thank you, and thanks to all three of you for those. Professor Jaffer, if you could, great, thank you. Thank you for those interesting and thought-provoking opening statements. I'll now recognize my colleague, Board Member Nitza, for the first question.
Oh, great. This is a question for Professor Jaffer. You mentioned at one time both sort of retaining the authority and then also potential for expanding it. And I'm just curious what your sort of legislative dream result would be. Would you want to expand the authority to, for instance, capture some of the evolving technologies, or simply retain it?
Well, I think absolutely I would expand it. In a couple of ways I would expand it. One, I think that the use of specific selection terms and the limitation on the NSA's ability to collect and hold the data in order to search it puts us at the whim of providers who may choose to retain the data or not. There's no data retention requirement in the USA Freedom Act. And so to the extent that providers choose not to retain the data, that data becomes unavailable to the government, to our intelligence community. So I would walk back some of the changes made by USA Freedom. There were some very beneficial changes made in USA Freedom, some of the transparency and reporting changes. But the core changes to the authority, I think, were unnecessary given what we knew about the potential impact on U.S. persons' privacy and civil liberties. That being said, even beyond that, even if you were to maintain the specific selection term requirements of USA Freedom, Professor Landau is right. Communications modalities have changed. That's not a reason to get rid of the CDR program. That's a reason to expand the CDR program to extend to other communications technologies like those that Dr. Landau laid out.
Thank you.
Thank you. I have a question for Professor Landau. You spoke today and you've written previously about how changes in technology are affecting the policy trade-offs on issues like these. I'd like to ask about what the effect of changing technology has been on the call detail record program and the relevant debate, but focusing specifically on what has changed since the time when the public and Congress were in the debate that led to the USA Freedom Act. So thinking back 4 or 5 years, what has changed since then that would affect how we might think about this policy discussion or issue now?
So I think, in fact, the change occurred already by 2006, although it wasn't necessarily 2006, 2007. And if you go back to the 2014 PCLOB report, it talks some about efficaciousness and different measures. But the changes in 2014 is when we saw ISIS at its most powerful, and at that point it had 46,000 Twitter accounts, for example. That kind of change in the way terrorists drove attacks abroad was not necessarily visible in 2015. It's clearly visible now. The other changes are that we have seen a wider array of apps that terrorists use to communicate. And so the model back in the early mid-2000s was the telephone, but by now that is for terrorists for HAVs, homegrown violent extremists within the United States. My comments are not about Europe, which has a different modality. But for HAVs, the modality is using internet communications.
Thank you.
My question is for all three panelists. What, if any, conclusions do you draw from the fairly large numbers revealed in the intelligence community's annual statistical transparency reports about this program? I believe the numbers are on the order of 500+ million records last year, 400+ million records in the most recent report, something on the order of 19 million unique identifiers contained in those records, and a arguably small number of initial targets, I think under 50, and perhaps even a relatively low number within that range. So what conclusions do you draw from that?
I think it's indicative of how individuals use telecommunication technology today. Again, as you've noted, the targets ranged in, let me see, I have the numbers
40
here.
targets.
40 targets.
40 and 42.
Right, thank you. So 40 and 42 targets in, I believe, 2016, 2017 under the call detail record program, compared again with the volume of records that you mentioned. The target, as compared to the variety of different communication techniques, apps, different facilities that target is using, I think is the distinction between, to explain in part the volume of records. Again, also indicative of that is, as you mentioned, the number of identifiers provided to the court that are linked to the target. Anybody with a smartphone today probably has 10 to 200 apps on it that have a variety of different communication capabilities within those. And so to the extent that those communication techniques fit within the call detail record program and the SST requirement, I think that's one of the explanations for the volume of records.
So I think the short answer, and now I'm coming at it as a mathematician, is multiplication. But each phone has a device identifier, a phone number attached to it, an account number attached to it, and presumably if one of those is already in NSA records, then when NSA does the first stop, it goes out with all of the selectors, not just the one that they originally came to. They do get permission to do so. But that's a multiplication factor. It's a small multiplication factor, but it happens twice. The volume of communications we do, and when I say phone calls, I really mean phone and SMS, the volume we do has been steadily growing. And it is particularly growing among younger people, and terrorists tend to be not people over 40, but people younger than that. We don't know if they have the same modality of communicating that the rest of us do. It's also the case that a terrorist may carry two phones, a terrorist phone and a personal phone. And once those phones are linked to the individual, the personal phone also, the records are collected. And then, of course, terrorist has friends and family just like the rest of us do. But when you get to multiplying the number of different selectors for an individual and the fact that that person will communicate, say, within 30 days with perhaps as many as 30 people, and each of those then communicate with 30 people, and the numbers I have seen lately indicate as many as 150 SMS and phone calls per day. That's for a broad user. Now, one of the problems with getting these numbers is, and this would be something that would be very useful for PCLOB to dig into, is what you want to look at is the median number of calls plus SMS text done when you take out the numbers that are generated by spammers and marketers, and what the right number is. But once you put those numbers into the equation, you come up with the 3.5 million on average for 2016 and the 4 or 5 times that the following year. It's not hard to get to those numbers. What it says about the privacy of Americans is a little harder to know because we don't know where those numbers are reaching to.
Professor Jaffer, did you want to address that?
No, yeah, thanks. Look, I mean, I think what it bears keeping in mind is that we're talking about here is metadata, right? We're not talking about the content of communications. And in a lot of ways, if you're conducting surveillance, metadata is the most privacy protective way of looking at data. Looking at large amounts of metadata allow you to rapidly exclude a large number of people you might otherwise consider for content collection. It also lets you include the relevant subset that are actually communicating with terrorists or terrorist-affiliated or suspected terrorist affiliates. And so in a lot of ways, metadata collection is the most privacy-protective way to conduct surveillance and actually reduces net the amount of content you're going after. So that's one real positive. The other thing to remember, as Dr. Landau has pointed out, is that we are increasingly in a world of encrypted communications. In a world of encrypted communications, all you have is metadata. And so the idea that today we ought to be taking sort of tools off the table when it comes to metadata, restricting those, we've already limited the number of queries going from, we were already in a low number, right? So say at the height of the 215 program in the pre USA Freedom Act era, we had about 462 some odd queries, okay? In the modern era, as Caroline and Professor Landau have just pointed out, we went from 40 to 42 in 2016, 2017. In 2018, we had 11 targets. Now, that's not because the terrorist threat has gone down so dramatically. It's that we put in place new procedures and requirements that made it harder and harder for the intelligence community to get to go after these targets. And so this notion somehow that the terrorist threat has gone down so much that we've gone from 462 to 11 is clearly not the case. And what it is the case is that it's these provisions we put in place and the access to data. And so, in a world in which the terrorist threat is large and continuing to grow, in a world in which we are moving encrypted data, we're moving to increased number of platforms and capabilities, want to ask ourselves, why are we taking tools off the table?
Could I just add very briefly, if you don't mind?
Sure.
Dr. Landau referenced this, but I think it's important for folks who aren't as familiar with the program to understand the role of the hops within the collection. And so obviously, while the targets may be small, the authority allows for not only the collection of metadata related to the direct communications, but also kind of the second universe of people who are affiliated with the target. And so I just think that's another important factor that could help describe the volume of records.
Great, thank you.
So a question for Professor Landau and Ms. Lynch. So both of you have spoken a little bit to how rapidly evolving technology has arguably made the CDR program less efficacious. And we, of course, have the Section 702 program, but that's limited in some respects. So I'm wondering if you think, given current technology, is it possible to have an effective metadata program that reaches domestically?
It's necessary to have one. The 702 is my understanding is that 702 is functioning in many ways as a substitute for 215 because 702 allows makes it much easier to do the IP collection of the metadata of IP communications, as well as the content, but the metadata of IP communications. But 215 is restrictive in that you can't target Americans under 215. Sorry, 702, I said that wrong. 702 is restrictive. And so I imagine there will be pressure to change 702 in that way because of the need to follow up on how the terrorists are communicating with Americans and what Americans are communicating with. Some of the terrorists are, of course, Americans overseas. Some of the ISIS recruits have been Americans overseas. And so the question is, how does 12333 work with 702, and does it capture the things that the IC needs? But that's the question I would be asking in concert with 215.
Yes, I think that it's important to maintain an authority that addresses modern day use of technology and that enables the ability to collect and analyze metadata. FISA is a statute that is specifically intended for the domestic collection of foreign intelligence. That's its purpose. And it specifically authorizes the targeting of U.S. persons because U.S. persons can engage in terrorist acts against the homeland. They can engage in espionage and act as foreign agents for hostile governments. And so the notion, I think it's important to kind of dispel that myth a little bit about the role of FISA and the potential that we can have members of our own citizenry that want to do harm to our national security. Whether that solution lies in expanding 702 authorities, versus modifying or even replacing CDR with something that more appropriately fits modern day communication techniques, I think is an important aspect for the board to explore.
This question is for all the panelists, and I will also hopefully have the chance to give our second panel an opportunity to address it. In your view, what specific privacy or civil liberties harms or risks attend the collection of call detail records in the manner we've been discussing today? And please be as specific as possible. So this type of data could be used in blank inappropriate way.
So I will start here, but I really want to defer and hope you get to ask Jonathan this question, since Jonathan Mayer has done great work in this. My favorite example is to imagine that one looked at the call detail records between the management at Oracle, the database company, and Sun Microsystems, where I used to work, the weekend before the Monday announcement that Oracle was purchasing Sun. And one can imagine that you see a call between the two CEOs, and then you see a call from the CEOs of each company to their chief legal officer, and then calls back, and then calls between the chief technical officers. And you don't need to know what the communication is. By the time you've mapped out the communication pattern that weekend, you know what the decision is. and that you know that Oracle is going to attempt to buy Sun. Jonathan has done wonderful work in looking at call detail records of you'll say how many people, and then mapping out not just general patterns of people's participation in church and calling medical and doctors and so on, but also in profiling 5 individuals, and I don't want to steal his thunder, but 5 individuals, and exactly by looking at who they called, you can figure out scenarios of what was going on in their lives. It is the case that metadata is remarkably revelatory. It is the case that call detail records are remarkably revelatory, but it is also the case that because the terrorists are no longer using that form of communication within the United States and from outside the U.S. into the U.S., or not using it in great amount, that it is not particularly useful anymore in this situation.
Is there a particular way in which you fear that hypothetical risk? And I don't mean to denigrate hypothetical risks. They are very important things for us to be aware of. But is there a specific way in which you fear that hypothetical risk could manifest itself, given the ancillary facts that we're aware of about the program
I'm not
and the
sure,
oversight mechanisms?
When you say hypothetical risk, you mean hypothetical
The
risk?
possibility of de-anonymizing metadata or drawing powerful
Sure.
inferences from metadata, given the specific facts of this program and what we know about the surrounding oversight and authorization mechanisms.
I'll level that up one and say that we've always viewed our government as operating within constraints and not giving authority when authority isn't needed. So could one imagine, if you go back to the Nixon era, for example, and trying to track enemies of the president, one can certainly see places where one doesn't want the government to have, didn't want then the government to have authorities it shouldn't have. And that's the way we've always operated in the United States.
I think I would just want to clarify that the use of smartphone technology, apps, and everything that is a part of our daily lives generates a tremendous amount of metadata. The universe, but the subsection, the sub-universe of metadata that is then eligible for collection under the Call Detail Record Authority is not the entire volume of metadata that an individual produces. So I just want to make that clarification when we talk about the privacy interests, particularly of American citizens. Obviously, it's an evolving conversation in the courts about the third-party doctrine, about the expectation that a person has in that non-content information that they generate through communication technology, and how that can be woven together to provide a roadmap, if you will, of a person's behavior or their communication techniques. And it's that tension between that and the ability for private companies to collect and maintain records in their course of business, and then to what extent those records can be made available to the government under appropriate process. I think, as Dr. Landau mentioned, the conversation that I hope Congress will have is with the intelligence agencies is what is the critical and useful type of metadata that actually helps you build the evidence that you need in your counterterrorism investigations in particular. There's a lot of noise out there that's not necessarily useful noise. So to the extent that that can be, there can be precision in that, I think that that can help narrow the potential concern about privacy and civil liberty intrusion.
Professor Jaffer?
Yeah, thank you. Look, I mean, there's obviously a significant potential, or as you described it, Chairman Klein, a hypothetical risk when you allow the government to acquire a significant amount of data and maintain it for some period of time. And as Dr. Landau has correctly laid out, you don't want the potential for a enemies list, whether it's in a Nixon, a Reagan, a Bush, a Clinton, a Bush 2, Trump or Obama era presidency to be available if you can avoid it. And so the question is not whether in the abstract there's a hypothetical risk, but have we seen any reason to believe that risk has become real? And we've had now 18 years of this program, part of it operating under presidential authority and part of it operating under court authority, all of it under oversight of the intelligence community, Inspector General, the various other Inspector Generals of the agencies, the Justice Department, the FISA court. I mean, everybody and anybody who has looked at this program. And the fact is, there's not one example, not one. Hundreds of millions of records collected, billions of records potentially under the prior program, not a single example of abuse, not one. And so this sort of idea that there's this hypothetical risk out there, sure, we should be worried about that. We as Americans have long come from our founding, have come from a deep place of skepticism of government authority, particularly when it comes to security matters. And it's a place that we should continue to maintain. We should be vigilant of our privacy and civil liberties. But when that trade-off, that balance has to be struck between protecting the lives of American citizens under a very real threat from terrorists and the potential risk of metadata, which can be revealing. And yes, in theory, you could build a profile of somebody, who they were calling, where they were calling, whether they were dating somebody or seeing their psychiatrist or their lawyer or their lover or going to a particular nightclub or the like. But the fact is, there's no evidence a single operator at NSA or anyone else or at the FBI or at the Justice Department or at the CIA ever built those profiles about anyone, whether a foreigner or an American, under this program. And so this sort of hypothetical risk of we're going to create, this massive database, I think, is just something you have to weigh against the very real terrorist threat. In the absence of that, the question is, what's the value? And if there's value, right, do we take that value off the table when there's no evidence of abuse?
Thank you, Professor Landau. You were mentioned in there. If you wanted an opportunity to respond, that's fine. Otherwise, we can go to the next question.
I think we can move on.
Okay, and I'll also note that we have a microphone here if there are members of the public who would like to pose a question to this panel. This is your chance. We would ask you to identify yourself and also to confine your question to an actual question and to make it as concise as possible out of respect for the panelists and for everyone else present. I do have another question for Ms. Lynch, but also for the other panelists if they wish to weigh in. Would you talk about the other expiring provisions, the 215 ordinary business records provision, which applies to any business records or tangible things, but which does not include the two-hop exponential collection authority that the call records provision does. There's also the lone wolf definition of who can be an agent of a foreign power for counterterrorism purposes, and then the authority to use roving wiretaps when a suspect is changing phones. Would you talk about those a bit?
Sure. So the way that Congress has approached the sunsets or the expiration date since the Patriot Act of 2001 is essentially to revert the statutes, the temporary statutes, back to the form that they had prior to enactment. So what that means is any change made to Section 215, specifically to Sections 501 and 502 of FISA, would revert back to, it actually says in the statute, October 25th of 2001, the day before enactment of the original Patriot Act. So as I mentioned earlier, if those authorities expire for Section 215 purposes, the call detail record authority expires, but so do all of the changes made in the last 18 years to that section, again, covering a wide array of issues, everything from the universe of records that can be obtained to the standard that the government has to meet, the prohibition on bulk collection. One of the things that the USA Freedom Act did is it actually empowered, prior to the USA Freedom Act, the FISA court could simply aver that the government had minimization procedures. The USA Freedom Act now empowers the FISA court to assess the veracity of those minimization procedures. Based on some cases that were moving through the courts, the Act expanded non-disclosure authorities to those who are the recipients of court orders, and additional things including liability and compensation protections for those who are the subject of the orders. All of that would essentially go away. And again, while that, if Congress chooses to not maintain CDR authority on the books in its current form or in a modified form, that's a decision that it needs to make, but the FBI's traditional use would then be significantly hampered. And I do want to stress that while the CDR program is a counterterrorism program, FISA is a foreign intelligence collection statute. There are investigations well beyond counterterrorism for which the FBI relies on Section 215 and other FISA authorities. counter-espionage, counterintelligence investigations. In this climate of threats from nation states, we need to be particularly cognizant of not stripping those authorities away from the Bureau. As you mentioned, Section 206, roving authority, enables the government to essentially follow the person. Prior to roving authority coming into practice, both in the criminal context and in foreign intelligence collection, if somebody used a burner or swapped devices or had multiple devices, typically the government would have to obtain a new court order every time a new facility or device came into use. And so roving authority has been in place since 2001 to enable the government to not lose track or create a gap in intelligence collection should somebody switch devices or facilities. And again, the lone wolf definition actually added as part of a 2004 statute, not as part of the original Patriot Act. As the definition of foreign power, an agent of a foreign power under FISA does not capture the situation where a person is not necessarily a card-carrying member of Al-Qaeda and ISIS or any other terrorist organization. And so it provides the ability for the government to take advantage of the surveillance authority in Title I of FISA when an individual is engaged in activities associated with international terrorism but isn't, again, necessarily an identified agent of that particular organization. All of those both 206 roving and lone wolf, in my opinion, continue to have intelligence value and should be and should be included in a reauthorization and kept in place, particularly as Dr. Landau mentioned, the manner in which foreign terrorist organizations recruit and enlist allegiance to their mission, membership into their organizations is much more loosely organized right now, and I think that it's critical for those to be kept in place.
So I would just like to add one small point, which is at the time that the lone wolf provision was put in, the privacy and civil liberties community worried a great deal about abuse of that, which does not seem to have happened. There have been occasional releases of information about how often the provision is used. It would be very good to see that released on a regular basis, and that's something that I think PCLOB should explore.
Okay.
And I'd just say one quick thing, which is that both Caroline and Dr. Landau are exactly correct. These provisions are important. They're critical to the national security. They're largely non-controversial. Roving, in a lot of ways, applied a concept that had long been applied in organized crime and drug cases to terrorism cases. And lone wolf, while, as Dr. Landau points out, has had fairly limited use, does have an important potential benefit in the scenario that we're seeing now with people who are more loosely affiliated with Al-Qaeda. I think the main important thing, though, here to emphasize is that, you know, we constantly end up in this series of sort of self-created crises, this brinksmanship that Congress engages in by putting in sunsets in these laws. Congress seems to have forgotten that it can change the law whenever it wants to. It doesn't need the emergency of a sunset provision to go in and modify the law once passed. It can go in and change the law any day, any year. And so Congress has got to get away from these self-created, crises of expiration, reauthorize the provisions as the way you want them, make them permanent, and then if you want to modify them the next year, 2 years later, 5 years later, but don't keep creating these crises where you have to go reauthorize it, otherwise you have this parade of horribles that, as Caroline has correctly laid out, you essentially wipe out almost 2 decades of evolution and practice and law because you couldn't just take your responsibility up and change the statute when you want to change it.
Just a quick follow-up. So the lone wolf provision, of course, applies only to non-U.S. persons. I'm curious if you have any thoughts on setting aside political expediency of doing so, whether for security reasons it should be expanded to U.S. persons.
I think that's something that Congress should take a very hard look at. Again, FISA is intended in part to enable intelligence gathering against U.S. persons that are intending to threaten America's national security. And so to the extent that its use is limited in that restriction to non-U.S. persons, when at the same time the violent extremist threat domestically, despite what news reports may claim or people may think, most of the recent terror attacks that have occurred on U.S. soil were carried out by U.S. citizens and not by foreign nationals that came into the United States, or by naturalized citizens. So yeah, I think that's something that Congress should take a look at.
Great, thank you. Well, with that, I'll just say we greatly appreciate your taking the time and rearranging your schedules to be with us today. All three of your presentations were extremely informative and helpful for the board, and I think interesting for everyone who was here. So thank you very much, and we will now invite up our second panel. I'll now introduce the second set of panelists for their opening remarks. Julian Sanchez is a senior fellow at the Cato Institute, where he studies technology, privacy, and civil liberties with a focus on national security and surveillance. Before joining Cato, Mr. Sanchez served as the Washington editor for the technology news site Ars Technica. Jonathan Meyer is assistant professor at Princeton University, where he holds appointments in the Department of Computer Science and the Woodrow Wilson School of Public and International Affairs. Before joining the Princeton faculty, he served as technology advisor to a U.S. senator and as the chief technologist of the FCC's Enforcement Bureau. And Michael Bahar is a partner at the law firm of Evershed Sutherland, where he co-leads the cybersecurity and data privacy practice. He previously served as the Minority Staff Director and General Counsel for the House Permanent Select Committee on Intelligence, where he worked on the USA Freedom Act and other significant intelligence-related legislation. So thank you to all three of you for joining us, and we will start with Mr. Sanchez.
Thank you very much, Chairman Klein and members, for inviting me to speak, and also to all of those who have chosen to take their time to either come in person or view on television this discussion. I think our starting point for talking about the NSA CDR program should be the finding of both previous incarnation of this board as well as the President's handpicked commission, that the predecessor version of this program was itself of highly limited operational value, and not merely that it was difficult to identify concrete intelligence successes attributable to the program, but that in particular, to the extent that it generated useful information that was in nearly every case duplicative of information already being obtained by intelligence agencies or law enforcement agencies pursuant to more traditional targeted orders. And I think that's important to stress, because it is not as though without the CDR program, the FBI and other agencies lack the ability to obtain communications metadata. Specifically, really, the discussion of this program should be about the question of whether the marginal added intelligence value of automatically iterating the acquisition of metadata to the first-order contacts of targets provides a significant benefit relative to the more traditional targeted method, where an additional choice is made about expansion from that first range of information collection. And so I think, when we look at the numbers involved, we should ask, is this volume of collection, and therefore, in a sense, an intrusion on the private communications of many millions of people, justified by a significantly greater intelligence value relative to a more targeted method? Again, if you look at the numbers that Chairman Klein cited, 40 orders on 40 targets in 2017, with 534 million communications records obtained. And then in 2018, 14 orders on 11 targets, with 434 million CDRs obtained, and they finally got a count of the number of different phone numbers involved, so about 19 million phone numbers. So we're talking about, in the instance of each order, many tens of millions of discrete communication records pertaining to, on average, over 1 million phone numbers or entities in each of those cases. And of course, the nature of this is almost certainly the case that the majority of records obtained will, just sort of given the math of this, pertain to communications between parties, neither of whom is the actual target or subject to whom suspicion pertains. I think it's worth saying that the judicial role in approving orders of this kind, when we're talking about tens of millions of discrete communication records, millions of people, starts to take on a bit of the aura of a kind of cargo cult formality. If we think about the traditional role of the advance approval by a magistrate, either of traditional search warrants or subpoenas, other kinds of requests for information, their function is in part not just to assess the adequacy of evidence presented, but the nexus between that evidence and the function of the search or the information acquisition, and the scope of the information obtained. It's the range of documents requested, germane to the topic of the search. And in this case, essentially, the statute has removed that question. Said by definition, the communications of anyone in contact with a target, and I'm assuming that at least some of these targets are not natural persons, but entities of some kind that involve numerous discrete individuals. Anyone in contact with those persons, their communications with any other person are automatically relevant. I think that is a system that gives us, in a sense, the performance of a traditional oversight function or a traditional judicial checking function without much of the heart of it. It's not really possible for those judges to be assessing the fit between the purpose and the scale of the collection undertaken. I want to sort of add and maybe dilate a little bit on what Professor Landau said earlier in terms of the what it means, what technological change is likely to have done to the efficacy of that kind of collection. And here I'd say, a couple things. One thing that is clear from the statistical report is that one reason those numbers are so large is that it includes numbers used for marketing purposes, or so. Telemarketers, maybe the legitimate sort if there are any, robocalls for spam are increasing, in a sense, the quantity of chaff, data chaff, coming into the system. At the same time, as Dr. Landau noted, people are increasingly shifting their communications, especially if they have even a casual regard for security, to a variety of other apps. Diffusing significantly the number of providers you would have to look at to have a comprehensive synoptic view of any particular individual's communication. And so I think, in the sense that a common response to the original findings of this board were that even if you don't have sort of affirmative demonstrated utility from this kind of large-scale collection, at least it has a kind of negative value, and it allows you to allocate resources more efficiently by ruling out options, establishing you don't need to pursue leads about a particular subject's foreign connections. Those technological changes, in essence, remove even that argument, in that it is increasingly difficult now to say, well, at least we have a comprehensive database, at least we can now rule out questions about following up leads about certain kinds of connections, because we know we have the full universe of communication. I would also note, it's worth, because this is called the Call Detail Record Program, that in thinking about the privacy implications of this kind of metadata collection, it's worth not thinking exclusively about calls, but also about SMS, because the pragmatics of how we use text-based messaging communications are quite different from how we traditionally use voice telephone calls. And that is to say, what in a voice phone call is essentially one contiguous discrete event representing a conversation with one metadata record. A conversation, sort of a functional conversation between two people, will very often be broken up over a series of discrete metadata events recorded in CDRs. And so in terms of thinking about the level of intrusion on privacy, we should think of collection of this kind of metadata as involving a much more granular look at the rhythms and flows of an interpersonal conversation in a way that will tend to reveal, I think, a fair amount more about the nature of a relationship between two people than merely the fact that a call occurred. I would also point to the compliance incidents that occurred, which I hope the board is looking into and which we don't know a ton about, but which I'm assuming involved significant overproduction if the remedy was to purge the database and repopulate it in its entirety as a result of technical irregularities apparently affecting multiple providers. And I think the fact that this occurred is a caution about automating and iterating data collection, and a reason to not make it a default, that is, to require a sort of second decision as we expand out from an initial point of interest, precisely because a relatively small number of errors at one stage end up iterated through an automated process, often to quite significant scale. So, at the first level, a mistake can lead to many thousands, if not millions, of additional communication records being improperly obtained in a way that becomes difficult to isolate. I would say, I suppose in particular, and perhaps partial response to Professor Jaffer, that part of the nature of collection at this kind of scale, in a particular automated collection, is that it does inherently make oversight more difficult. When you look at what the FISC said about compliance incidents that occurred under the initial bulk version of this program, this is, I think, in a colloquial sense, equally bulk given the numbers involved, even though nominally selector-based and therefore not bulk in the sense the intelligence community uses the term. What you find is that the scale and complexity of the program, the volume of data, made it often difficult to notice when data was being accessed in ways that were non-compliant with the court's restrictions. And so I think, in a sense, restricting the quality of data ingested is itself a mechanism for making oversight more tractable. When you talk about so whether the harms are hypothetical here, I think Professor Jaffer is facing us with a bit of a catch-22. If there are if you don't catch any compliance incidents, well, there's no problem. It's great. If you do detect compliance incidents, the system is working, and yet again, there's nothing to worry about. And I think that's fundamentally an error. That the scale of collection means you have made it more difficult to identify, in particular, deliberate compliance incidents, precisely because those are the most likely to evade attention, because accidental compliance incidents don't involve a party taking countermeasures against detection. If you think about historical intelligence abuses, the fact that a wiretap was ordered on Martin Luther King, let's say, would in itself be a red flag that might direct you toward a misuse. When collection is automated, when so many millions of people and communications records are ingested as a sort of a threshold measure, you complicate the task of overseeing that and distinguishing accidental from deliberate compliance incidents. And that's why I would sort of close with sort of a caution. I think it's clear that I think this is a program that seems never to have had enormous utility. It seems to involve just an enormous amount of, therefore, unnecessary collection of intimate communications data pertaining to people who are not suspected of any wrongdoing themselves, and therefore should be allowed to sort of quietly die. That the same way information security professionals regard it as inherently a security risk to unnecessarily retain data without purpose, we should consider both the risk of retaining the data itself, but also of, for expediency reasons or otherwise, retaining an authority for which we know no current use. But I would also urge the board to consider what the alternative is. There's, as I said at the outset, a wide range of authorities and mechanisms by which the intelligence community gathers communications metadata. 215 is in many ways relatively restrictive, and so while I think it would be wisest to allow this particular authority to expire and allow other authorities that don't automatically iterate communications collections to be the mechanism for obtaining this information, we should attend to where the collection is going to flow, what other authorities that will gravitate toward, because it would be a sort of Pyrrhic victory for civil liberties if we said this particular program will expire and instead other authorities bound by fewer restrictions will be used to get substantially the same data. And so I hope in its analysis the board will be considering what the likely substitutes or perhaps already actual substitutes for this authority are.
Thank you. Professor Meyer?
Thank you, Chairman Klein, Board Member Nitze, and Board Member Felton for the opportunity to participate in today's public forum on the USA Freedom Act and the Telephone Records Program operated under the business records provisions of the Foreign Intelligence Surveillance Act. During my recent government service at the U.S. Senate and the FCC, I experienced firsthand the value of the board's independent and nonpartisan expertise at the intersection of national security and privacy, and in particular, the value of the board's 2014 report on the Telephone Records Program. I'm glad that the board is once again considering that program as it approaches its sunset date, and I'm especially appreciative of the board's efforts to incorporate science and engineering in its assessment. In my opening statement, I will focus on providing a computer science perspective on the Telephone Records Program. I would be glad to answer the board's questions about the legal dimensions of the program or other components of the Foreign Intelligence Surveillance Act. I'd like to address three topics in my opening statement. First, I'll provide an overview of a peer-reviewed measurement study that I conducted with computer science colleagues on the Telephone Records Program. Second, I'll offer possible policy and legal implications of that study for the board's consideration of the sunsetting FISA business records provisions. And third, drawing on the metrics that our team used in our study, I'll recommend some possible directions for improving the transparency reporting associated with the FISA business records provisions and the Telephone Records Program. The study that I've referenced is entitled Evaluating the Privacy Properties of Telephone Metadata. Really creative, right? It was published in the Proceedings of the National Academy of Sciences in 2016, and it is publicly available on the National Academy's website. Before turning to the methodology and results of that study, I'd like to acknowledge my exceptional co-authors, John Mitchell and Patrick Muchler, without whom the study would not have been possible. The goal of our study was to rigorously understand the privacy implications of the Telephone Records Program. We developed an Android smartphone application that enabled members of the American public to submit their call and text message records, as well as their Facebook profile information. We then analyzed that data using statistical and machine learning models, free and commercial databases, and manual assessments. Our study included over 800 individual participants, over 250,000 call records, and over 1 million text message records. The first component of our study examined telephone usage patterns, which we conceptualized as an interconnected graph of telephone numbers. We found that telephone usage patterns vary significantly. Some phone numbers are rarely used. Many numbers, predominantly belonging to individuals, are used to communicate with a small community. And some numbers, predominantly belonging to organizations, are used to communicate with a large number of individuals. These are numbers like customer service lines, voice-over internet protocol bridges, and multi-factor authentication services, as well as telemarketers and spammers. We statistically extrapolated from the telephone usage patterns in our data set to understand the consequences of the hop restrictions and the durational limits associated with the Telephone Records Program. We concluded that under the pre-USA Freedom Act Telephone Records Program, a single seed query could, in expectation, be sufficient to examine telephone records involving a significant proportion of the entire United States population. We also concluded that under the Telephone Records Program, as restructured by the USA Freedom Act, a single seed query could, in expectation, yield telephone records involving conservatively tens of thousands of unique numbers and possibly orders of magnitude more. Next, we examined the feasibility of identifying the individual or organization associated with the telephone numbers in our data set. We achieved moderate performance at identifying telephone numbers using automated requests to free databases, and we achieved high performance using manual analysis and a combination of free and commercial sources. We concluded that a well-resourced organization would very likely be able to match identities to telephone numbers rapidly and at large scale. Third, we assessed whether it was possible to infer an individual's home location from their telephone records. Using a machine learning algorithm, we achieved high accuracy at predicting the city where an individual lived. While we did not have the data to assess more precise location predictions, we hypothesized that a well-resourced organization could achieve greater accuracy and precision. Fourth, we sought to identify personal relationships from telephone records. Again, using a machine learning algorithm, we achieved moderate performance at predicting whether an individual was in a relationship. And among individuals who were in a relationship, we achieved high performance at identifying their relationship partner. Finally, we attempted to draw sensitive inferences from our data set of telephone records. We found that many participants in our study had placed calls to sensitive organizations, such as medical practices, religious organizations, or political groups. We were able to draw remarkably precise inferences from these call records, including a participant's religion, specific medical conditions, and firearm ownership, including make and model. Having reviewed the methodology and conclusions of the study, I'd like to offer some possible policy and legal implications for the board's assessment of the telephone records program. First, there are several common factual misunderstandings about telephone metadata and the structure of the telephone records program. These common misunderstandings include that hop limits and retention periods necessarily function as narrow constraints on the program scope, that telephone metadata does not pose a significant privacy concern because it is not identified, and that telephone metadata does not pose a significant privacy concern because it is not sensitive. These factual misunderstandings have been shared by all three branches of government and on both sides of the aisle. The board's 2014 report includes a thoughtful discussion of these topics, and I encourage the board to reaffirm and expand on its prior factual assessment of the privacy properties of telephone metadata and the telephone records program. The second possible implication of our study that I would encourage the board to consider relates to the structure of the telephone call graph. As I mentioned earlier, one of our key findings was that some phone numbers disproportionately communicate with other phone numbers. These so-called high-degree phone numbers exist at the national level, like customer service lines, but also at the local level, like medical practices. I encourage the board to examine how the intelligence community has addressed these high-degree phone numbers, which are unlikely to produce information related to international terrorism, but may result in the transfer of a large volume of telephone records or a particularly sensitive group of telephone records from service providers to the intelligence community. Under the Foreign Intelligence Surveillance Court's pre-USA Freedom Act orders authorizing the telephone records program, the National Security Agency had the authority, but not the obligation, to address high-degree phone numbers within the data that it held. The board's expert assessment of how NSA has addressed high-degree numbers following adoption of the USA Freedom Act will be a valuable contribution to transparency surrounding the telephone records program. The third direction that I'd like the board to consider, drawing on our study, is the overall policy merit of the USA Freedom Act telephone records program. In its influential 2014 report, the board recommended ending the bulk telephone records program under the FISA business records provisions. Congress legislated consistent with that recommendation in the 2015 USA Freedom Act. But the USA Freedom Act replaced the bulk program with a different telephone records program, under which the intelligence community can still obtain a large volume of telephone records from service providers. The board's 2016 recommendations assessment report noted that Congress had implemented the board's recommendation to end the bulk telephone records program, but neither that report nor any subsequent report has provided an assessment of the restructured telephone records program. I encourage the board to provide that assessment to Congress and to the public in advance of the approaching USA Freedom Act sunset date. In conducting that assessment, I encourage the board to consider whether the shift from bulk acquisition to high-volume acquisition is sufficient to address the board's constitutional and policy concerns surrounding the telephone records program, or whether it would be appropriate to amend the FISA business records provisions such that telephone records requests are subject to the same procedures as all other business records requests. I'd like to close by encouraging the board to consider how the intelligence community and Congress might improve transparency reporting for the FISA business records provisions. Put plainly, it remains difficult to discern what the privacy consequences of the FISA business records provisions are for ordinary Americans. I encourage the board to consider the feasibility and merit of reporting the number of identifiers used for business records requests, the number of call detail records and telephone identifiers acquired at the first and second hops of telephone records queries, and the distribution of the number of telephone records associated with each telephone identifier. I also encourage the board to examine the technical feasibility of improving the telephone records program transparency reports by eliminating duplicate call detail records. Finally, I would like to encourage the board to consider studying whether new approaches to privacy-preserving data analysis could be valuable for the intelligence community's transparency reporting. Recent advances, including differential privacy and secure multi-party computation, could enable more comprehensive transparency reporting while rigorously protecting sources and methods. Thank you again for the opportunity to participate in today's public forum, and I look forward to your questions.
Thank you. Mr. Bahar?
Yes, thank you very much, and thank you very much to each of you for having me today. You know, I realized when I looked at the date that it was 2 years ago today that I left full-time government service. And now I'm in the private sector, and people often ask me, you know, what has changed? And the thing that I always say is Windows. For the first time in my career in about 16 years, I can actually have a window, because I'm not dealing in the national security classified environment. But as I was thinking about, you know, the call data records, the other thing that struck me too is, you know, now I don't have to keep documents in safes. I don't have to shred everything. And as I go around to many of my partners' offices who have been lawyers in the private sector for much longer, one thing I've really noticed, and you've probably noticed this as well, is people hoard a lot of paper, right? It's all over their desk, they're all over their office. It looks like they're swimming in a sea of paper. And if you ask them, they assure you, well, believe me, I know where everything is. And I doubt that. And I bring that up because one of the things that is so valuable in what we're doing today is, you know, if every national security tool is on the table in the office, then nothing is. And the question is, you know, is this tool going to be worth it, right? Professor Jaffer was talking about things like, you know, why would we ever take a tool off the table? And that's when I started thinking about our partner offices. Well, you're not going to be able to get something necessarily if you have everything on the table. And also pinging off what Professor Jaffer said is, you know, especially for tools like the call data records that do have significant privacy impacts, having a sunset really does force this reassessment, this reevaluation, this balancing of whether the intelligence that's being provided is actually, you know, valuable and whether it's worth the impacts it have on privacy. And similar to Professor Mayer, I really, you know, think back to my dog-eared copy of the PCLOB's report in 2014, and I'm very encouraged that you're starting to do a similar assessment of the value and the efficacy and the impacts of the newly revised metadata program. And it's been almost 5 years since the Congress passed the USA Freedom Act. And as you mentioned, Chairman Klein, I worked closely on this act with some colleagues here, and I really enjoyed working with the colleagues on the then majority and the Senate and the administration to actually, you know, preserve the capability, but not necessarily the methodology, to eliminate bulk collection, but to still allow the intelligence community to have a valuable tool should they need it. But in that 5 years, a lot has changed. I think it's really important to reassess what has changed, and I think we've hit upon this in the first panel and the second panel, but to really go through it again, first thing that has really changed, that it potentially changes the equation, and that's ultimately what we're looking at as an equation, is it worth it, is the dangers of the misuse or abuse of personal information in general has become more readily apparent, right? There's rarely a day that you don't look at the papers now and see some corporation or some foreign country being accused of massive privacy violations, right? That's largely a feature of what has changed number 2, which is technology, right? The ability to sift through vast quantities of data, to make connections, to use artificial intelligence, big data analytics, to actually put it all together. Now, disparate pieces of information can be readily put together to perform, you know, whole pictures of individuals, right? So the privacy impacts of even seemingly innocuous pieces of metadata have gone up, right? just in absolute terms, they have gone up. Right. Third, we've got global regulations, right, who are now all over the world. They're recognizing these two trends, and they're passing sweeping privacy regulations, in a sense to force companies, including governments, to better internalize the costs of privacy. And one of the things that these regulations are really doing is making anybody who collects data undertake a cost-benefit analysis or a necessity proportionality assessment. And that's really what you all did 5 years ago, and I would encourage that, again, to take a look and say, here's what we're collecting, here's its impact, and then draw the conclusion, and therefore we think it's worth it, or we think we should make changes, or we should eliminate it. The other thing that has changed, and the fifth thing, which goes to the idea of all the papers on the desks, are the opportunity costs. The threats have changed, right? Carolyn was talking earlier about, and she made a very good point, that this CDR program is just a counterterrorism tool, right? But 5 years come hence, we are now seeing very different geopolitical threats. And what's important to realize is that we passed the USA Freedom Act in, 2015? On 2016, both the then chairman and then ranking member of the House Permanent Select Committee on Intelligence went on the floor of the Congress and publicly questioned whether the Intelligence Authorization Act, the funding mechanism for the intelligence community, is prioritizing too many resources on counterterrorism and not enough on the so-called hard targets, the near peer and peer competitors. I think fast forwarding to 2019, we see the true resurgence of great power politics, where yes, we still have a very viable CT threat, counterterrorism threat, but we also have a very serious threat posed by nation states. And if we're spending a lot of our time and resources on potential value, are we taking away from actual value? Again, that's a question, and I think that's something that needs to be looked at, but I think we need to be very careful to not, just because the CDR program is focused on CT, to only look at it through a CT lens, because there's a lot of other stuff going around. Now, that could also be an argument that cuts in favor of expanding the program beyond CT, and maybe looking to see if there are any sleeper cells or espionage elements from foreign countries. Or it could be something that says, you know what, this money, this time, these energies are better spent elsewhere. So when we track all those things that change, there's one thing that hasn't changed that is also worth considering, and was alluded to a little bit earlier. The nice part about having congressional authorization is that when the IC uses the authority, it's subject to those strictures. If you remove those strictures, we could have a reversion to the idea where we can use inherent presidential authority or executive branch authority to accomplish similar goals. And I know that animated some of the Congress 5 years ago to say, well, we better do something here, because if we don't, maybe the executive branch is going to step in and fill the void, as was previously happened, and then we would have no oversight over it. We'd have no ability to cabinet, no ability to have all those different privacy-enhancing features, and that would be a net negative as well. So those are really the points that I wanted to make. And the last thing I did want to say is, again, the beauty of having a forced crisis, as Jamil would say, forced reevaluation. It does give us the opportunity to make reforms, right? So if we're finding that it's not that effective, but it could be really effective if we did this, this, and this gives us an opportunity to do that. If we find out there are better ways or greater ways to enhance privacy, for example, defining what does it mean to have activities protected by the First Amendment of the Constitution, maybe we can spell that out some more. There are ways that we can change the equation that way. So with that, I thank you very much, and I look forward to your questions.
Great, thank you, and thanks to all the panelists for their statements. I'll offer my colleagues the opportunity to lead off the questioning.
Thanks. I'd like to ask a question based on Mr. Sanchez's statement, but I'd be interested in hearing from all of the panelists on it. You highlighted in your statement a couple of things that are distinctive about this call data records program. First of all, that it extends to the second hop, but I want to focus on the other thing that you highlighted, which is the what you referred to as the automated collection aspect of it, which comes from a change that Congress dictated in the USA Freedom Act. Right before that change, the structure of this program was that a phone company would, pursuant to a court order, turn over to NSA the complete set of call data records they had, and then NSA would query that subject to procedural rules. And the change that was made was a change to a structure in which the phone companies held the data, and NSA would reach out and, in effect, query for only the data that falls within 2 hops. How might we think about? And let me say one more thing about that before to put the question in context. And you referred to the technical irregularities that NSA had reported, which had led to some data being produced to NSA that should not have been produced. Although still the amount of data that was produced was presumably less than would have been produced under the previous version of the program. So how might we think about the policy issues around this change in structure and the move to a query-based approach as opposed to a full production approach? And what might the board do to help illuminate this issue for the public in Congress?
So I mean, certainly relative to indiscriminate production, this is obviously somewhat less intrusive, although, again, the numbers involved suggest it's still on quite an enormous scale. In terms of sort of how to think about that automated second stage, I think perhaps combining this with the question Chairman Klein asked about, where the risks are, I think the automation of that second step, at least, if not relative to the bulk program, relative to the traditional mechanism for obtaining telecommunications metadata records, is that it removes from scrutiny questions that would otherwise be a sort of an occasion for potential oversight or intervention. You imagine a case in which an FBI agent goes to the FISC court, a regular criminal court, asking for records on the comprehensive telecommunications records over the course of some months on a reporter or a religious institution or an activist or a medical institution. It might, given the details of the case, that might perhaps be justified, that might be granted, but probably heightened scrutiny would be applied, additional stringent procedures might be applied, minimization procedures, and certainly, the court would be on notice that this sensitive subset information was underway. Essentially, automating the second stage means all of that scrutiny doesn't happen when the same information is obtained, not because someone is trying to make a specific showing that those records are relevant, but merely because a suspect has had one contact with a reporter, a religious institution, a medical provider, a political candidate. I don't know if that gets into the neighborhood of what you were inquiring about.
Yes and no. So certainly, if one is comparing the current structure to alternatives, one alternative would be one in which only the first hop of data would be provided in response to a court order, and then an agency has to go back and get a subsequent order. Now you're pretty close to the existing pen, register, trap, and trace kind of authorities.
Right.
But if you're talking about a structure which contemplates a second hop of collection somehow, the question is, how does one think about an automated second step of collection versus upfront production of a full data set?
Right.
And how can the board help to inform Congress as it thinks through these issues?
This may be closer to John's wheelhouse. Let me think about that for a second.
So maybe a few thoughts. One being, I think it's important to play through the hypothetical alternative, right? So if you were to move from an automated second hop to a court-approved second hop, what would be the burden on the intelligence community, and what would be the change in intelligence value? That is a difficult hypothetical query to engage in, but I think it's certainly worth trying to engage in it to the maximum extent possible. My second reaction is that I think in thinking about the privacy implications of the shift from bulk production to high volume production, that depends a lot on how you think about privacy. If your concern, for example, is that a large collection of records could be problematic in the event of a data breach, holding fewer records poses less of a privacy risk from that perspective. On the other hand, if your concern is misuse, for example, someone inputting a seed query or querying within data holdings in a way that might be improper, then perhaps that risk might be not as diminished. So again, it really depends on how you think about privacy.
Yeah, I would tend to agree with that. You know, one thing, and when we were thinking about the hops, it's rare that two big-time terrorists talk to each other, right? The same way in espionage, it's rare that you're going to have a direct contact. They're going to use things called cutouts, right? And part of it is figuring out this network and this chain, especially when cutouts are used. So in one sense, the value of the program is going to be greatly diminished if you limit the hops. But of course, the more hops, the greater the exponential sweep of records. And if you're thinking about in terms of potential misuse, then you start to look at, can you use more controls, right? And I think, again, your original report found there was no intentional misuse, right? Nobody has ever found it. Professor Jaffer was very adamant there's never been a misuse. That didn't surprise me. However, it's also worth thinking about that the history of this program isn't very long. Right? There have been intelligence abuses and uses in this country, right? And this program has not been around that long. So it's also important to keep that in context.
And so, in terms of the pragmatics of the distinction there, I mean, so given the sort of permissive presumption of relevance that 215 makes in sort of the individualized case, in essence, the second hop would always effectively be approved absent special considerations. That is, the records of someone pertaining to someone directly in contact with the subject of an investigation would be presumptively within 215's terms relevant. So it's sort of a situation where an agent could not turn around and essentially get the second hop fairly quickly. And so you might imagine in practice someone doing that effectively automatically. What I would hope is in the the step between having received the first record, from some combination of privacy and efficacy reasons, that would be an opportunity to focus in on contacts that are, at least there's some reason to believe are relevant to the topic of the investigation, and to weed out things like spam call and telemarketing numbers, or potentially numbers pertaining to large institutions, or that appear to or are known to pertain to sensitive organizations or persons. So it's an opportunity, if not for privacy reasons, then just to try and mitigate the sort of drinking from a fire hose problem, to be more selective. And again, to avoid an initial technical error being magnified into large-scale accidental production.
Thank you. I'd like to throw in a follow-up to this related to the phrase used by Mr. Sanchez, automated iterative collection mechanisms, which for the general public watching at home, I take to mean machines checking in with other machines on a recurring basis and automatically pulling back responsive records on a recurring basis as well. And let's assume for purposes of argument that that's a meaningful distinction in various ways. If so, would you, and this would, maybe Mr. Bahar would have something to say about this as well, as having previously engaged in the legislative process, is this something that should be reflected in statute? And as we know, statutes in this space typically talk about the what is the government entitled to get and with what's showing, rather than specifying the technological means by which it's empowered to do so. Is this something that Congress should speak to in this or other statutes of this type? The technological setup the government it envisions being employed to collect the information, or is that too granular to address in statute?
That is hard to answer in the abstract. I think I share the general presumption against sort of specifying technical mechanisms in advance. There are contexts in which it would be, I think, fairly innocuous to do certain kinds of acquisition in an automated way. It's the combination of automated iteration that, at least in this case, gets you potential problems. It would depend on a specific. You have to sort of talk about a specific piece of text addressing a specific technical measure that was excluded, rather than, I think, kind of affirmatively specifying a mechanism to use.
And I think to put a finer point on this, if I can interject, if, as you suggest, an automated iterative setup fundamentally changes the nature of the program in certain ways, how does Congress know what it's buying when it enacts an authority if it doesn't have a specific idea of how it's going to be implemented and whether it's going to be implemented in this way? Mr. Bahar, you may have some thoughts on this, whether this is an oversight matter.
We actually debated this quite a lot, and that's why the words technical assistance are in there. One, of course, from a legislative perspective, trying to enshrine in statute any type of technology is fraught with peril, because by the time it passes, it's probably obsolete. And to talk about engineering, a crisis every time the technology changes, you don't want to have to come back and do that. But you can put parameters around it, the same way we did for CISA, the Cyber Security Act of 2015. It was another area where we thought about the technical capabilities and whether to mandate that or not. And it was also similar to the Freedom Act in the sense that speed mattered. So having that machine-to-machine speed was really important, certainly for cyber threats as well as for terrorism threats. And this revised program, the CDR program, is more technologically complex, right? Because you've got multiple providers, you've got to fuse all this data, you've got to put it in a usable format to allow all this call chaining. So there's already a degree of complexity. And I think what you can do is maybe, again, provide parameters, provide checks, include that in minimization guidelines, but I don't think you can enshrine technology in statute.
Thank you.
I have a question. This is for Professor Mayer. So you conclude your testimony by saying that recent technological advances could enable more comprehensive transparency reporting while protecting sources and methods. So I was wondering if you could, two-part question. One, sort of give some examples of what those might be, and then two, speak to whether they're commercially available now or sort of just sitting somewhere in a lab.
Sure. So the two advances I touched on were secure multi-party computation and differential privacy. Secure multi-party computation is a sub-area of computer science that enables multiple entities to collaborate in coming up with a number while having rigorous guarantees about what each of those entities will learn in the course of that computation. And so if you wanted to generate rigorous statistics about aspects of collection that involved multiple phone companies or multiple email providers, or any other, to use the term for computer science, federated computation, you could do that without having the concern that each of those participants might learn sources and methods, might learn about internal operations of the intelligence community. So that's the promise of secure multi-party computation. With respect to differential privacy, that is a sub-area of computer science that enables computing statistics while having guarantees around what the statistic might disclose about individual items in the data set that the statistic was computed about. The traditional application of differential privacy has been to protect consumer privacy, and it is deployed increasingly within the technology sector. Secure multi-party computation less so, though it has seen some deployments. And again, traditionally has been used for consumer privacy, but the exact same guarantees could be applied to protecting sources and methods. And so the reason I suggest both of them as an area for possible study is there's been a recurring challenge of getting multiple entities to collaborate in providing transparency around collection. And there's been a recurring challenge around providing bands around collection. Kind of how precise are the numbers you can give about particular dimensions of collection. And these technologies offer some promise in addressing those concerns about collaboration and those wide bands.
As a quick land gap to that, I would just say I think that the issues are often not technical. The FBI has been exempted from reporting a number of things that other intelligence agencies are required to pertaining queries run against some of these databases, largely on the basis of effectively a design choice they have made to architect their networks and their systems not to create an audit trail of the data in question, or at least in an easily accessible or reportable way. And that seems like a sort of perverse incentive to create, to say if you've chosen not to design for accountability and transparency, you will be exempt from the obligation. I hope it's not excessively cynical to say very often things that are said to be technically infeasible very quickly become feasible once an entity is told you are nevertheless obligated to do it. So I think the technical issues there are not the central obstacle.
For the two, I am not an expert in this area at all, so for the two examples that you noted, so differential privacy and secure multi-party computation, what would be some of the challenges, if at all, to sort of applying it to the CDR program that you could foresee?
It's difficult to predict without having access to the data set. One of the lessons of industry adoption of these approaches has been that often they require some calibration to the particular context they're using them in. So with the caveat that this is a degree of speculation, I think it would be actually quite natural to apply differential privacy to some of the aggregate statistics that are already reported about the call detail records program to provide greater precision in the results. With respect to secure multi-party computation, I think the potential value there might be more around Section 702 collection, where there are challenges around different providers holding different information about email addresses and other electronic communications handles. I'm cognizant that we're focused on Section 215 today and not Section 702, so I'd be happy to talk more about that offline.
I'd like to pitch the same question that I pitched to the first panel to you all. What are the specific, concrete privacy or civil liberties risks or harms that you think could foreseeably result from the collection and retention of these specific types of records that we're talking about here, by the specific entities that we're talking about here, and subject to the specific safeguards and constraints that we're all aware of? So please be as concrete as possible. You can probably tell that I want that by the fact that I repeated the word specific about 15 times in that question. Okay, go for it.
Well, like a good academic, I'm going to start by resisting the framing. The framing certainly assumes that privacy and civil liberties could depend on specific harms that might occur. But there are other reasons to protect privacy and civil liberties, including, for example, concerns around free speech and chilling effects, concerns around human rights at home and certainly abroad. So I want to make sure to caveat up front that that is one lens through which you might think about privacy and civil liberties issues, but is not the exclusive lens, perhaps. With that said, I think there are discrete possible harms to think about. and they're not too difficult to spin out. So one that we've heard a few times today is the risk of misuse. And it is true that there is no known instance of intentional misuse under this particular authority, though it is important to caveat that with the fact that there have been misuses of other authorities. And I think it's important, as always, to keep in mind that absence of evidence is not the same as evidence of absence. It is not necessarily the case that we would know if there were an instance of misuse. Data breach is the other sort of immediate possible risk that comes to mind. It is certainly the case that other components of the U.S. government have had data security issues, and at least according to some public reporting, there have been data security issues at NSA itself. I'll leave it at that.
Again, I'll offer the opportunity for members of the audience to ask questions. I don't have NSA or Princeton computer science level technical skills, but I think I can safely say that that is a roving microphone. So if you feel more comfortable asking a question from your seat, just stick your hand up and we'll deliver it to you. In the meantime, I wanted to ask about the widespread reporting in the press that terrorists are increasingly shifting to using encrypted applications rather than telephony, and Professor Landau described this shift in compelling detail in her testimony. Assuming this is true, and I think we all accept that it is, what are the implications of that shift in your view for this program, but also for the broader array of legal authorities available for counterterrorism, and feel free to propose changes in those authorities that are responsive in any way that you see fit. Maybe Mr. Bahar, you can start with this one.
Yeah, I mean, that's one of the things that has certainly changed over the last 5 years that changes the equation, is that the value of the intelligence is naturally going to go down because, A, people know about call chain analysis, right? It's the 215 debate of 5 years ago was very public. Of course, the Snowden revelations were very public. And, without going to things that we can't go into, it's fair to say that, the terrorists know as much as you can, stay off your phones. Or if you're going to use your phones, throw them out, use a burner phone, use a cutout, or start transitioning to encrypted communications, the so-called going dark problem. I don't think the CDR program is going to address those. If there is a way to, as Professor Jaffer was talking about it, expand the CDR program to somehow get to encrypted communications, okay, but just using the structure of it now with the telecommunications companies, and that's where you're drawing the data, I don't necessarily see that as being possible or feasible. So as both the legislator and the P Club and others are going through the equation as to whether the intelligence is worth it, the transition that the terrorists have made to other forms of communication certainly tips the scales a little bit to diminishing the value of the intelligence. Doesn't mean eliminating it, but it certainly does diminish it.
Assuming that communications metadata from some forms of communication remain very valuable investigative tools, which legal authorities do you think are potentially most important for getting that which is useful, and do you think those are sufficient?
That's a great question. I mean, we can look throughout the rest of FISA for those authorities, right? Because they are potentially business records outside of call data records. We'd have to sort of check the definitions to make sure that's the case. But I think there are plenty of tools that could be used. And oftentimes the metadata is all you have. So I think the metadata on the secure communications, the encrypted communications, are probably far more valuable at this point than the metadata of traditional telephony. Again, there is always the possibility that somebody picks up the phone, right, and calls another person, or calls a flight school in Florida, the same way that happened in 2001. That's always a possibility, but again, I always go back to that, the desk full of papers, the office full of papers. Yes, there's plenty of stuff there, but are you going to have what you need when you need it? And if you've got everything, you got nothing.
Could I ask a follow-up on that?
Yeah.
Just to clarify on your last answer, would the result be different if you're talking only about one hop? The question of, do you have current authorities that allow you to get one hop information from a broad variety of messaging systems versus a two hop version of it?
I don't think so. I think obviously the privacy impacts for every hop increase, but the intelligence value also increase with every hop. Because again, what we talked about earlier, very rarely do people communicate directly that you're trying to get to, right? Sure, if you're just trying to stop an imminent attack, it doesn't matter, just stop it. But if you're trying to figure out an unfolding plot, trying to say, I know the selector of this bad guy in this country, is he or she communicating with people in the United States? That's unlikely to be direct communication. There will be a series of cutouts. So I really do think you need the hops to, and again, that's the point of CDR, right? It's the call chain analysis, the chain being it. So
Thank you. So a couple of thoughts in response. The first one being, I want to highlight that, well, communication systems are changing and certainly moving increasingly to the internet. The structure of the communications themselves, I mean this in a certain sense, is not really changing. Namely, you've got some group of parties, and you've got the time of the communication, when it starts, when it ended. There may be some information about the volume of the communication. And then the communication may be among federated service providers. So telephone or email are good examples of those. We have a bunch of entities participating. And more recently, the trend has been towards centralized service providers. So for example, Apple's iMessage or Google's messaging service. That's kind of the design space. There's not been a tremendous amount of creativity in practice. Plenty in the lab, but not really in practice beyond that. And so as a result, I don't think it's that hard to sketch what the technical requirements would need to be to get metadata off of any foreseeable new communications platform. What I think is perhaps the harder question, and a harder question I saw firsthand at the FCC, is facilitating the interface between the government and those new platforms. Making sure the government can get the data it needs quickly and in a useful format. And often there can be breakdowns between service providers and government, and there I think there's an incredibly valuable role for the board to play.
Well, absent any further questions, I think I will wrap things up here on behalf of my colleagues. I'd like to thank, first and foremost, the 6 experts who came to testify before us today. I think their contributions were uniformly very thought-provoking and informative, and given us a lot of value to take back as we continue our work and our examination of the implementation of this authority. You highlighted what are the two very and equally compelling interests at the heart of our agency's mission, preserving the expectations of privacy and the civil liberties and civil rights that we as Americans hold precious as our birthright, and on the other hand, our memory of 9/11, of the lessons of the 9/11 Commission report, and our understanding that we cannot revert back to the pre-9/11 status quo that enabled the attacks to succeed. Finally, I'd like to recognize Jen Burita and the other members of our staff who worked so hard preparing this event, as well as the members of our staff team who are working very diligently on our examination of this authority. And of course, thanks to all of you for attending, and we hope to see you at future events. Thank you.